Our live feed going. You're not, you don't have to be stuck. You're welcome to sit there. Okay.
Can Ms. Hodge hear you yet?
I don't know. We'll figure that out in a sec.
Okay.
Good morning, Judge. Thank you.
Try that, Judge.
Okay. Mr. Pinion, can you hear me? Ms. Nelson, can you hear me?
Yes, Judge.
Okay. Ms. Hodge, can you hear me? Mr. Pinion, are you there?
Yes, I can hear you, Your Honor.
Okay. We're going to be doing this from your clothes closet?
No,
Okay.
I'll come out.
Let me know when you can be in a stationary spot.
Okay, I'm there.
We're going to talk about Mr. Lowe right now. He's on the calendar for us to figure out what's next. He's got two matters. The 10 SC case, which are a murder charge. I don't know what the 8 SC case is. Not serious, but I'll look it up while we're talking. But I'm going to let Mr. Franklin start. Just give us an update as to where he thinks the defense is, and then I'll hear from you, Mr. Pinion. You just need to keep track of this case.
Yes, Your Honor, I spoke to Mr. Abadi, who had been handling the case, and the stance, he had discussed it with Mr. before, that the defendant had a previous murder case, and that this was the second one, and that if he is restored to competency, then we are not interested in taking a not guilty by reason of insanity. We would be willing to accept a plea of guilty but mentally ill. Otherwise, we are prepared to the case to move forward to trial.
So you're saying that your understanding is that Mr. Lowe has been accused of killing two different people and two different incidents.
Yes, Your Honor.
Okay?
The earlier incident preceded this one. I believe it was from Maryland possibly, or another state.
Okay.
I think it was might be my manslaughter.
Okay.
The,
The 08SC case is still open. It's an aggravated assault. So we would certainly be focused on the 10SC case rather than the aggravated assault. I understand what Mr. Pinion had to say. What's your sense of where we are, Mr. Franklin?
Based on my earlier discussion with Mr. Body, basically what Mr. Pinion has said, I think I understood it a bit differently in that I perceive the potential holdup, the conversations that Mr. Body was attempting to have with Mr. Howard. I had a conversation with Mr. Body and I asked, well, you know, if Mr. Howard's not in the picture, you know, how do you feel about it? And he wasn't 100% either way in terms of whether he would entertain the not guilty by reason of understanding or guilty by the deal. The central point that we have already is, as you can tell from the age of the case, Mr. Lowe has not been in the docket rotation for some time. He had been incompetent. If I remember correctly, he had been not restored. And then he was.
And yet he was restored.
Yeah, he was restored.
Okay.
The case was previously handled by Luana Walsh, who was the deputy supervisor attorney in my office. I assumed the case because her role has changed in our office since this case came to be. We both visited him at Georgia Regional over a year ago. My takeaway from that conversation is that he, although he may be able to parrot back some of the answers to competency questions, who was the judge,
The basics.
yeah, I don't believe that he's going to be able to assist his defense at trial. So there's this question of whether what he's actually at it.
Hold on one second. Now, you need to have that turned off, okay? All right. Yeah, I was looking at the docket, and in 2017, Judge Downs entered a order of civil commitment. Those aren't irreversible, but that's a sign of something. And then about a year and a half later, January of 2019, Judge Reeder, who had assumed Judge Downs's docket, entered a judicial hold, the first sentence of which said the defendant has been deemed not competent to stand trial, and he'll stay in judicial hold until he is deemed to be competent. And then 6 months later, there was a lift of the hold, but there's nothing else in the docket. So presumably there's things going on that maybe you're aware of, but there's nothing for me to review to get a comfort level of what restoration means or who has opined what.
The return to competency, I believe, would have been done around the time that Judge Downs was retiring and Judge Reeder was assuming her docket. I don't believe that there was a new finding of incompetence at the time that Judge Reeder did docket the case. I could be wrong.
I think she just
Certainly is one of the cases that I touched on a daily basis.
Yeah. I think maybe as she assumed the docket was wanting to get cases in the right place and put Mr. Lowe on judicial hold. There's nothing else in the docket. There's the July 2017 entry, the order of civil commitment, and then 18 months of nothing. And then Judge Reeder says, let's put this on judicial hold because he's been deemed not competent. So I think that's probably Mr. Williams saying we need to have folks in the right spot, should be on an active docket. And then 6 months later, there's a lift of the hold, but again, no documentation. So Mr. Pinion, it seems like to me that the right next step would be for us to put Mr. Lowe on a status calendar for late winter or early spring, so February or March, which would allow a couple things to happen. One, Mr. Franklin and you, Mr. Pinion, and Mr. Abate, if he's going to stay in the mix, can have a conversation with the new management team in the DA's office to see what the perspective is. And I'm not in any way suggesting you've got the wrong perspective on it, Mr. Pinion. I heard what you said. And it may be that that doesn't change, but Mr. Franklin is correct in observing that that there may be a different way the case is assessed come the new year. The other thing I'd ask you all to do between now and then is to try to get some, and if you need my help, I'll sign an order, but we need to get some documentation from DBHDD about what's been going on, because the docket isn't helping. And I'm not doubting that good work is being done to assist Mr. Lowe and maybe to restore him, but we don't have any of that paperwork. Does that work for you, Mr. Pinion?
Yes, it does, Your Honor.
Mr. Franklin?
Yes, sir.
Okay, so what I'll ask Ms. Nelson to do is to get this on a status calendar for late February, early March. If something comes up before then where we need to do something on the case, just let Ms. Nelson know. In particular, if it's to help get paperwork from DBHDD. But if there is some resolution to the matter, we can also address it. I don't want us to forget about Mr. Lowe, but if he's in fact at Georgia Regional and not at Rice Street, he is probably at the safest place for him right now, all things considered. Okay, and he's listed as a low now, so that's where he is. So he's getting the care and treatment he needs, and it sounds like that's been going on now for 10 years, which is indicative.
Yeah, I think there may have been times where he was believed to have been restored or decompensated fairly quickly, which is why he just stayed stage.
Okay. Yeah, in 2015, there was a flurry of activity, and in the middle of 2016, maybe there was going to be a trial, but then to your point, he went back. So the decompensation is prompt. Okay. All right. Anything else, Mr. Franklin, as to Mr. Lowe?
No, so just clarifying, when new management is in, I can reapproach Mr. Pickens, Mr. Body, to kind of re-ask what I have been asking and see if it falls in different areas.
And it may be that the status calendar is too soon because new management is going to be digesting a whole lot of stuff, but that we won't lose track of Mr. Lowe. And we'll touch base and you guys can give me more realistic.
And the second half is just getting clarification on the paperwork with DPHD in terms of how we re-arrive at this posture. In terms of a clarification on whether there's a new incompetency thing that kind of.
Right. I would like to get something from DBHDD that says, as of late 2020, here's where we think Mr. Lowe is, because there's nothing.
Yes, sir.
All right, Mr. Pinion, anything else? Mr. Pinion, you there? Ms. Nelson, can you hear me?
Yes, sir.
Okay. Oh, is he frozen? Mr. Pinion's frozen.
They didn't transport low, did they?
They did not, no.
Okay.
We're going to do Mr. Strobel right now. We'll get with Mr. Pinion later. Just want to know how this afternoon is going to work. Thank you. Yes, that's correct. And he needs to come down. I just got a text saying that for some reason, he was brought on her slot and will be moved down here once you have room down here. Great, but if there's not room here, we can handle Mr. Strobel right now. He's next up. And I don't think that'll take real long.
Okay, we'll do Strobel out. Somebody else.
How do you tell me how you'd like to work it? Do you want to go get Jackson first, or do you want to?
No, we'll do Strobel out. Somebody else.
Okay.
Just so you're on the notes, I am wanting Carter Cell out here, so I don't know how many we have before that, but, you know,
Is Mr. Matt up?
yeah, I just,
Okay, well, we're gonna do Strobel and then we'll do Matt.
thank you so much, Judge.
Sure. And Carnesale will sit tight, I'm sure.
Well, that actual motion hearings for this afternoon with Mr. Boyle's client. So, I mean, I don't know if he needs to be transported down to our holding cell immediately, but I just want to make sure he's not lost.
Yeah, before you rush up, we don't need Mr. Jackson until this afternoon. But if Judge Krause needs him out of her space, you can move, but he's on the 1:30 count.
Okay.
So there's no rush to get him. I just didn't want Judge Krause to be saying he's burning a hole in my, I need space. If she needs space, we'll take him. If there's no pressure, you get him at your leisure between now and 1:30. Okay? I don't see Ms. Snyder here. I don't see Ms. Hall on the call. So I don't know what we're doing with Strobel.
Good morning, Your
Well,
Honor. I'm actually filling in for ADA Hall this morning.
Great, thank you for doing that. She was not looking real healthy yesterday.
And she is not doing well today.
Okay,
And it's my understanding that Mr. Strobel's case is going to be null prost.
okay. Well, he'll be happy to hear that when he comes on out.
Judge, I think you have the indictment on your printer.
There it is. And this will be as to Mr. Strobel. Did we already resolve Ms. Cartwright's case? Do you know, Ms. Nelson?
I do believe so, Judge. I'll double check, but I think so. Yes, Ms. Cartwright's case is closed.
Great, so this will take care of it. Okay. You can stay, this will be very quick. You're welcome to stay right there, Mr. Arnold. Good morning, Mr. Strobel. How are you?
I'm fine.
Good. I got some good news for you. My understanding from the state is that they're gonna dismiss the charges against you. Not necessarily because nothing happened in this case, but at this point, this isn't the case that the district attorney's office is gonna go forward with. Is that a fair statement, Ms. Hodge? She said yes, but she's on mute. Do you have any questions, Mr. Strobel?
I'm sorry.
That's okay. Do you have any questions?
None other than absolutely appreciate it.
Okay, well, my hope for you, Mr. Strobel, is that you can stay out of a mix like this. If you need help, hopefully you'll reach out for assistance in places that might be able to provide it. Hope you have a safe November and December. Do you have a place to go when you get out?
I do, sir. Fortunately, I do.
Okay, and where's that?
I'm doing a program that's called Plea.
Good.
And they've been very helpful to me. I do have plays I go to the once a week.
Okay, well, I'll sign this. You should get out today or tomorrow. If it is Thursday and you're still in, you should reach out to Ms. Snyder, your lawyer, to let her know, and she'll let me know, and we'll figure it out, okay? That's assuming nothing else is holding you in. I don't think so. I think this is the only thing holding you in, okay? Good luck, sir.
Thank you.
Matt, please, thank you. Ms. Hodge, are you handling position 4 also, the final plea in Mr. Mack's case?
Yes, Your Honor.
Great. Morning, Mr. Matt. How are you? I am okay. I think today we're going to have a conversation about final plea. Mr. Arnold, I need you to remind me, this was on a final plea calendar about a month and a half ago. And we didn't go forward with the final plea, but I don't know why. I normally ask Ms. Hall, but Ms. Hodge is graciously subbing for Ms. Hall, so I'll ask you to remind me why we didn't handle this last time.
Yes, Judge, just to refresh the court, the state had not transferred all of the discovery to myself at the time. There were about 3 lawyers before me. It got mixed up. Each lawyer said they didn't have it, so I just went back to the state. The state announced that they would go ahead and get that over to me. It was a really large file. I did receive that about 3 weeks ago. But today, Judge, I received, and Ms. Hall did tell me that it came yesterday, recording of my client's statement.
Oh.
So I think that would be vital. And although I would never ask for a third final plea, Judge, but under these circumstances, if we could have at least 10 more days, just to take that into consideration.
We don't have a lot of time pressure in the sense that I cannot unfortunately offer Mr. Matt a trial right away, as you know, although hopefully early in the new year, we'll be able to do those kinds of things if that's the way this case is going. It may well be that what's in that envelope fundamentally changes your thoughts about what Mr. Matt ought to do or not. I don't know if Ms. Hall gave you a preview of, it's a full-blown confession or it's a complete denial, or who knows, but whatever it is, you're entitled to see it, review it, discuss it with Mr. Matt so that he can make a fully informed decision about what he wants to do. So I'll tell you what, I will give you 2 options. One would be that we put this on a final plea calendar, maybe in December. Folks are sort of in and out in terms of their schedule. Or what we could do is say we will move Mr. Mapp's case to a trial calendar, but preserve his final plea rights so that when we have that calendar and he's brought back, we can have the discussion that we would have had on a final plea calendar. I did that with a few defendants yesterday, and it just takes the pressure off of, well, I'd like to digest more of this. I need to meet with my client, but that's complicated right now. I'm fine with either one.
I like the second option, Judge.
Okay. Then what I'll ask you to do is please let Ms. Nelson know if before that trial calendar is published, you and Mr. Mapp have sorted something out. Let her know. There's no need to wait for that. I cannot give you a date right now for when that calendar would be published. Mr. Mapp's been in jail for a while, so it would be one where he'd be higher up on it, not at the highest. Unfortunately, there are people who've been in longer than Mr. Mapp, but that at least will ensure that we continue to move the case forward. But if you and he and the state reach some solution, or even it's just going to be a non-negotiated plea, but you both know this is not a case we want to try, then why delay the plea? And let Ms. Nelson know, and we'll put you on the next available calendar. Otherwise, we won't bother you again, or bring Mr. Mapp over here again until we are calling that trial.
Sounds good.
Does that work?
Yes, it does. And just for the record, we didn't receive a written order on our bond motion. I did see in Odyssey that it just said bond denied, just rather boilerplate. I was hoping that was an error and you were still thinking about it.
Well, let me look in the docket here.
Okay, thank you. And just so the court's aware, Mr. Mapp's mother and several family members are in court to support him today, Judge.
Hello, family. Thank you for being here. No, it was a regular order. I don't know, maybe the way you're able to get into Odyssey or when you looked, but there is a.
Oh, it was filed in order, actually?
Yes, sir.
Okay, I'll check to see if I can go down.
Sure. It's there as of 9/29. Yep. September 29th. Mr. Mack, Mr. Arnold will be talking with you soon, but did you follow what I was saying? It sounds like your lawyer just got some more important information about your case. He's going to want to process it and probably talk to you about it. And then you and he, they decide that you want to try to work the case out, get you back in court and see if it can be worked out. You and he may decide it's something that needs to be a trial. You're certainly entitled to that. We're working hard to get trials up and running again in court. And as soon as we can, we'll get you on that list of defendants saying, I want my day in court. Okay? Do you have any procedural questions for me? Questions about your case, the substance you want to say for Mr. Arnold? But I'm happy to answer any other questions you've got. Okay, well, I'm glad you're doing okay. It's good to see you. Let me make sure Ms. Hodge doesn't have anything for the state. Ms. Hodge, anything from the state?
No, Your Honor.
All right, thank you again for covering for Ms. Hall.
Welcome.
Judge, just so I can confirm, that's going to go to a final plea, no, trial, reserving the final plea rights?
Yes, ma'am. That's exactly
Okay.
right.
Thank you.
All right, and Mr. Arnold, do we need to let Judge Carnesale's folks know that you're on your way, or you're not going to be sideways with them?
They were aware. I notified them that I was
Okay.
here first. but-
Great. You're welcome. Thank you for being here.
Have an excuse?
Yes, sir.
Thank you so much.
So we can do Mr. Tutman now, please. Good morning, Mr. Tutman. Ms. Hodge, you ready to talk about Mr. Tutman's case?
I am, Your Honor.
All right, Mr. Franklin, good morning. We're on for a final plea. That hasn't really been how things have been moving forward over the last few weeks. What is it? I noticed that you filed a motion to get your client's cell phone, and we'll talk about that. I don't know that that affects final plea all that much, but it may if you have a good faith basis to believe that that's got some pretty good exculpatory information. It's kind of an old case for this just to come to light, but hopefully they still have the phone and it can be powered up and all that. But tell me what you think we're doing today.
I received a offer from Ms. Hodge, it's a light offer, which we would not be accepting.
Okay.
The purpose of requesting the phone is more for our mindset of trial preparation. We believe it contains some communications from the mother of the outcry witnesses that color the situation such that we believe that it can show motivation for a basis to lie.
Okay. And your client had some connection to the mother.
Their cousins.
Okay. All right. Ms. Hodge, was the phone something that your investigative team has already worked with, or were you even aware there was a phone?
No, Your Honor, I was not aware of the phone.
Okay.
So my understanding wasn't part of the actual investigation. I believe it's property, not myself, it's with the county or with the actual police department. Typically, with most clients, I get called later on after they release and have to help get it from APD, the precinct location on Howard. So that's what I requested. It may turn out that when I go to them, they say, oh no, he's actually in property at the jail, and I may have to come back for the same motion, but identifying a different entity. But it's an order I've been intentionally trying to get to you for some time. I just hadn't physically done.
Okay. So if you can send a proposed order, you don't need to e-file it, just email to Ms. Nelson, copying Ms. Hodge, the order you'd like. I'm fine signing an order to get you, Mr. Tutman's phone, whether it's at the precinct on Donnelly Hollowell or ultimately at the jail. I guess you may have to knock on both doors. So I think it's a reasonable motion. And if it's not in the district attorney's possession, then you should try to get it from one of those places. So I'll just look for an email from Ms. Nelson forwarding your proposed order, and that ought to help you. So they wouldn't give it to you without the order because you're not Mr. Tutman or.
That's how it's operated in the past. So this would just be being proactive. Wow.
No, that's smart. They shouldn't give it to you without an order. Okay. So do you, much like we handled things with Mr. Matt, the offer is the offer. I mean, my thought is we move Mr. Tutman's case to a trial calendar, but I assist you as needed in getting the phone so you can do what you want with the phone. And that may change things. And if the state has a different offer, we can get Mr. Tutman in here. But I don't know that it's real productive, given what the state's offer is and the nature of these charges, to say, well, let's do another final plea.
I wasn't going to ask for another final plea, just in the realm of possibilities, how things may change with the administration change. I would ask to maintain property rights. But in my conversation with Mr. Tutman, and I believe Mr. Tutman, I don't believe that we're going to be seeking a number that would be agreeable to the state.
Okay. Ms. Hodge, were you able to hear Mr. Franklin?
No, Your Honor. The only thing I could really make out was that he wasn't asking for a final plea. So I'm assuming that we're just going to continue it to a trial calendar and reserve the final plea rights.
That's correct. And then Mr. Franklin added that his sense is that the state and the defense will remain fairly far apart in terms of what the two sides think a reasonable resolution is. So I think that is just another reason to move Mr. Tutman's case to a trial calendar, but preserve his final plea rights in case there is a change in circumstances.
I agree, Your Honor.
Great. We'll do that. And I'll assume everything is a go for trial unless I hear from you, Mr. Franklin, that we got the phone, but now I need to get an expert because it's locked and Mr. Tutman doesn't remember the password, whatever you might run into. All right. Ms. Hodge, anything else in Mr. Tutman's case?
Nothing from the state, Your Honor.
Mr. Tutman, do you have any questions of me about just the procedure, not the facts of your case, but sort of what's going on?
Yes. I filed a motion for a bond hearing because like my mother contracted COVID-19 and so on and so forth. And I also have a lawyer. I have a paid attorney now.
Okay, well, let me break that into two pieces because you've got a real good lawyer standing right next to you who actually was just doing work on your behalf. I see your motion here, but it's going to seem odd because, of course, it's your case and your charges, but you cannot file something on your behalf if you have a lawyer, whether it's Mr. Franklin or whoever you're about to tell me about. If you want to represent yourself, you can file things every day if you want, but if you file a motion for bond, or I sometimes see motion to dismiss an indictment or motion for a speedy trial, I am legally obligated to ignore it because the person who speaks for you legally is right now Mr. Franklin. It may in a while be this other lawyer, but unless and until we have a real long hearing about you wanting to represent yourself, the person who needs to file things for you would be your lawyer. So I didn't ignore it in the sense of I don't care about Mr. Tutman. I can't respond to something you file when you have a lawyer.
Well, and then on top of that, I've been trying to reach out to Mr. Franklin and I get no response. So That was the reason we filed the motion myself.
Okay, well, Mr. Franklin is working with lots of clients, and it's complicated times. So I'm not defending him, I'm just explaining that in my experience working with him, he doesn't ignore folks, but he triages. And so if there was something, by which I mean, what's the most urgent? If he's got a hearing with a detective coming in, he's gonna be working with that defendant. And then when that's over, he can turn to some of his other clients.
One thing I will add, John, he's correct. You understand the situation with how we visited people at the jail now, that kind of thing, and not being in the office. And I don't think I properly communicated to Mr. Tutman that I'm not in the office every day. So I believe he's correct that he's trying to call me and I've just not been able to pick up. So it has been a minute since I've visited at the jail. So he's absolutely correct about
Yeah, and that's unfortunate. It's not because Mr. Franklin hasn't been working, it's because of these difficult times. And it used to be someone could pop down to the jail and see 5 people in the afternoon, but there's not a lot of that type of visitation going on. So that doesn't mean your charges aren't important or folks aren't working on your behalf. We were just talking about a motion that Mr. Franklin filed on your behalf to try to get this phone. But let me explore this second thing with you. You tell me you now have hired a lawyer. Do you know that lawyer's name? Mr. Tolles? Okay. So in order for Mr. Tolles to become your attorney of record, the person who could come into court and speak on your behalf or file something on your behalf, he has to file what's called an entry of appearance. A 1-page document says, I'm now Mr. Tutman's lawyer. He has not done that yet. And that may be because he hasn't been paid all the way. I don't know. That's an arrangement you or your family will be making with Mr. Tolles. But unless and until he files an entry of appearance, it's not official. And so again, you can't file things that will have legal effect. And Mr. Tolles isn't the person who's speaking for you. So I don't know if you haven't finalized the financial arrangements with him. If you feel like you have, if he asks for X dollars and you know your family's giving him X dollars, then you need to bug him about filing that entry of appearance. Once he files an entry of appearance, Mr. Franklin ethically and responsibly can say, well, I will let go because someone else has replaced me. And then I can turn to Mr. Tolles to say, well, what's next? And he may say, I want a bond here. He may say, I'm trying to get Mr. Tutman's phone. He may say X, Y, whatever he's going to say. But he needs to file that entry of appearance first. Does that make sense?
Yes, sir.
Do you have any questions about that?
I have a question about other,
Okay. Well, I'll tell you what, I know Mr. Franklin's going to be getting in touch with you soon because of the phone situation and then what you just shared that you're feeling like maybe there hasn't been a connection recently. So if you think of the things, you can let him know. If there are things I need to answer, he'll let me know. But there are probably things he's in an even better position to answer. And he'll probably want to talk to you a little bit about the Mr. Tolles situation so that if you do hire Mr. Tolles, he can try to get to Mr. Tolles all the work he's done so that Mr. Tolles starts out a little bit ahead of the curve. Okay? All right.
I apologize. I was told that an offer of 20 years was offered me, then an offer of 10 years was offered today. And honestly, from what I'm saying now, I've been in jail 2 years now. If the 10 years of split sentence, like you have like time served, get out back my family, you know what I'm saying? I will accept it.
Okay. So
I'm sorry, Your Honor. Can you repeat what he just said?
I will, and I will. So Mr. Tutman said that he thought the offer a while ago was 20 years.
Yes, I was told.
Okay.
I was never offered.
Okay. He says, and I'm going to ask more about this, but he said he was told that the offer was 20 years, and then more recently he was told the offer was 10 years. And then he went on to say, you know, if it was like a split sentence and he could get time served, he might plead to that because he wants to get back to his family. So that, did you hear what I just said, Ms. Hodge?
I did, Your Honor.
I'm going to ask Mr. Tubman a question. I don't want you to get into the substance of what people were telling you beyond what you just shared with me, but you just finished telling me, Mr. Franklin hasn't been talking with you recently, but then you said someone just told me the offer was 10.
Yeah.
So that wasn't Mr. Franklin, I assume.
Last year when it went on, Mr. Franklin visited me on a video visit. That when he told me that offer came from the DA for 20 years. Then when Mr. Toles came and visited me, he was like, yeah, from what I looked at and spoke with some people, they was like, the offer that you have on the 17th something 2 years.
Okay. Well, that'll be something for you to explore with Mr. Toles, and maybe I'll explore it with him if he's here in court with you. Ms. Hodge, have you ever spoken with Christopher Toles about Mr. Tubman's case?
Never, Your Honor. Mr. Franklin is the only attorney I've spoken with about this case. And that offer is not in the records for this file at all.
Okay. And it's not what we're dealing with today. So Mr. Tubman, two important things, and I don't want to keep you here any longer. One, offers are good when they're made, but unless the lawyer tells you, and we'll leave that open, if you don't take the offer, then there's no guarantee that the next day or the next week, that'll still be the same offer. So I don't know about the 20, that was before my time. I wasn't working with this docket then. But this 10 that Mr. Toles mentioned, that may have been his assessment of the case, that, this case is not as strong as the state thinks, or these are serious charges. And so he may have had a professional basis for telling you 10. But you just heard Ms. Hodge, she's the prosecutor. She's not talked to Mr. Toles. So there may have been a miscommunication, but it doesn't sound like he, Mr. Toles, had been told by the prosecutor that 10 was in the works. That doesn't mean it won't be once he gets involved, but you heard what the offer was today. And I understand why Mr. Franklin said what he said, which is, we just get Mr. Tubman on a trial calendar. It's an old case. He deserves his day in court. And in between now and then, there's a new offer that makes more sense. Maybe we'll explore it, but otherwise, we need to get this case tried. And that's what I plan on doing. If you are free to have any lawyer you can afford. If you cannot afford a lawyer, you'll have the lawyer standing next to you, who is the most senior public defender in this courtroom, and would be in good hands. But that's up to you to decide. If Mr. Toles comes in, he'll have plenty of time to get ready for whatever is going to happen in the case. But he needs to file that entry of appearance. Until he does, I need to look to Mr. Franklin for guidance as to what's happening with the defense side of your case. All right? Mr. Franklin, anything you want to add while we're here? You're good.
Only that we don't take him down right away. I would like to speak to him. I need to get to that.
Sure. Ms. Hodge, anything else on Mr. Tubman's case?
Nothing further, Your Honor.
So what we'll do is we'll move Mr. Tubman's case to the next available trial calendar. This is one of our oldest cases, and you've been in for a long time, Mr. Tubman. That doesn't mean you're going to have a trial. Again, you may work the case out, but at least we'll get you there. But we'll preserve your final plea rights, meaning if there is some offer, maybe you're kind of thinking you'd explore, or it's non-negotiated, the state's going to recommend X and your lawyer's going to recommend Y. You could still enter a plea, and if you don't like the sentence you get in that plea, you can withdraw your plea, and then we'll get a jury in here to have the trial that you're waiting to have. Okay? So Mr. Franklin's going to come see you in a little bit. I think actually it's going to be in about a minute, because this is it for our morning calendar. And you guys will catch up some. And then if Mr. Toles files that entry, we'll get Mr. Toles in the mix, and we'll go from there. Okay? I appreciate your questions. All right, I think that's it. Were you folks, you're here for Mr. Tubman? Okay, I just want to make sure we had taken care of whoever you were here for, and you were here for him. Thank you for being here. All right, so we are our 11 o'clock is not happening. So if Mr. Bush was brought over, he can go back. We tried to intercept Mr. Bush and have him not come over, but we didn't learn that till yesterday afternoon. So what we need for 1:30 will be Mr. Jackson and Mr. Goolsby. Those are our two. We got a bond hearing on Jackson, and we'll do that first. And then we've got motions for Mr. Goolsby.
We go ahead and go get, Mr. Jackson.
Sure, however you want to work it. You're good. You've got, it's 10:19. You got a bunch of hours. And I'll be out here at 1:13 for that. Ms. Hodge, thank you for covering for Ms. Hall. The two cases in the afternoon, one is a gang case, so Ms. Convery has that, and then the other is a major case.
Okay, you're welcome, Your Honor. See you tomorrow. Thank
All
you.
right. Give Ms. Hall our best.
Will do.
See who else is on. Ms. Rolak, you'll be joining us this afternoon?
Yes, Judge, I will.
And Officer Crawford, if you would be on for the bond hearing, that would be helpful. But once the bond hearing's done, you'll be free to go because the Goolsby motions hearing, that's going to be a motions hearing. That is not going to surprise us with a plea. And I don't think Jackson will surprise us with a plea, but because it's a bond hearing, it's helpful to have Department of Community Supervision on, if that's all right with you.
Okay, I don't have the calendar with Mr. Jackson. I just have one with Goolsby.
Okay, what can we share with you so you can look Mr. Jackson up?
Either the case number or the SID.
I'll give you the case number. It's 18 SC 162-228.
Okay, in the calendars that we just had, I just wanted to make sure the other three were reset and number 2 was no cross.
Correct. One's going to a status calendar, 2 are going to a trial calendar, and position 2 was dismissed, no cross. That's right.
Okay, thank you.
11 o'clock calendar is off. Great, thanks everyone. I wonder if it's a different Zoom or if I'm supposed to stay. Yeah. Same one. So, but I think we don't have to leave this on. I can just open it up again. I won't touch that stuff. But.
Right. I'm going to see if I can get IT down here. But we're just on the verge of having it just right. I don't know what happened, why